Hi everybody, welcome back. Today we're going to be talking about the jury and the role of the jury, but also the theoretical and important role that the jury serves in our system. Again, this is not going to be like if you guys are in psych and law and we talked about jury decision making. This is going to be a very, very different lecture because this is going to be much more kind of theoretical in the sense of why did we even develop this idea of a jury. As always, here are the readings that you guys will need to know for the exam, so it would be a really, really good idea if you guys read these prior to the exam. And again, as always, here's an outline of what we're going to talk about. So juries started, I guess in general, trials started as trials by ordeal, right? And this was something we've seen kind of little nods to this in the media with stuff like Monty Python and stuff, when it's like, you know, if you're a witch, you won't float when we throw you in the water, or you won't catch on fire, or something else. Trials by ordeal, both parties would actually kind of fight, and whoever won clearly was the winner. That was the person that was right. My wife and I kind of do this and jokingly do these trials by ordeal in our home. If we get in a fight, we play a game of cards, and whoever wins the card game clearly won the fight. The origin of the jury can be traced back to the old Anglo-Saxon law in England. The jury originally made accusations on behalf of the crown. We today call that jury the grand jury. The church forbade the clergy from taking part in trials by ordeal, leading to an opening for the jury as kind of this finder of fact. Eventually, it evolved into adjudicators, and the transformation was kind of coupled with the Enlightenment philosophy of Europe. Juries came to America with British settlers also around 1607, and it's referred to in in 3 of the first 10 amendments to the Constitution, right? 80% of jury trials take place in the United States, which also shows that juries in the United States are very, very important. So why do we value this trial by jury? Why do we care about the jury? Is the right to a trial by jury basic to our system of jurisprudence, our system of law? I mean, the jury was included in the Declaration and the Bill of Rights as a protection against arbitrary rule. But why did we decide that that was the case? Why is it that we have this kind of dependence on the jury? In fact, the First Continental Congress objected to trials before judges dependent upon the crown for their salaries, right? And that already, if you see, can start kind of showing why we care about trials by jury, right? Judges were paid by the crown, which meant the judges served who? The crown. Jurors, on the other hand, were not paid by the crown, right? So who was their allegiance to? Really just their fellow citizens, right? And so already this is controlling power, giving it to the people from the government, right? The Constitution and Bill of Rights guarantee a right to a trial by an impartial jury of one's peers, and states have all pretty much adopted these standards, right? Now, granted, Florida, it's a 6-person jury versus a 12-person jury in most other states in the federal government, but regardless, they've still adopted the basic idea of a jury. The guarantee of a jury trial is a couple things, right? It's a protection from the oppression by government. Again, the power is with the people because the jury ultimately has the decision. And it's also a reflection of our beliefs about the exercise of official power. Why? Well, if you think about it, right? If we disagree with a prosecutor charging somebody with a crime, what can a jury do? If a jury is just the community sentiment, the jury can say not guilty, right? Because we don't think that you should charge for that. And we'll talk about that. That's called jury nullification. And we'll talk about that here in a couple slides. But that's an important power, right? It's a reflection of our beliefs. We don't think, maybe, that marijuana should be illegal. So everyone who gets arrested for smoking weed, if we just find them not guilty, we've pretty much outlawed the law against marijuana. We've legalized drug use, right? There are a couple different functions of our juries, and you'll definitely need to know these for the exam. But they're predominantly used in trial courts, right? There's issues of law, right? They legitimize behavior under the law that they function as. They function as issues of fact, such that they interpret and decide between competing and conflicting interpretations of events. And they also kind of serve as a referee in an adversarial contest to an extent. They also inject community sentiment or act as a check on our system of justice, right? As a political institution, de Tocqueville framed trials by juries in 2 different ways, right? Judicial which we've talked about, right, and we all know about, but also as this political institution. And it's important to see juries as this political institution, right? Juries place the direction of society in the hands of the governed, right? It rises citizens to the bench of judges, because, truthfully, the execution of our laws are entrusted to very common citizens. We don't have professional juries. And in fact, a lot of people say we should have professional juries, and that would mean that Casey Anthony, and O.J. Simpson, and George Zimmerman would all have been convicted. But we cared about something more than their conviction in their trials, right? We wanted the execution of the laws to be entrusted to the common citizen. In all three of those cases, we kind of said the media isn't the one trying this case, the people are. And we want the state to prove stuff to us beyond a reasonable doubt, and they didn't do that in those cases. And so it's better to let those guilty people go free than have those people suffer if they might be innocent, right? This is further evidenced by the jury's involvement in civil justice, right? And we see this a lot when it comes to monetary things, right? Like, well, how in the world did a jury pay a woman $1 million for spilling coffee on herself, right? It raises the visibility of the jury to say, no, the jury's the one deciding this stuff, right? And it also teaches people to practice equity. What is fair? How do we decide what's fair? How did this group of people decide what is fair in this case? Now, we've already referenced jury nullification earlier in this lecture. Jury nullification is the right that juries have to nullify or refuse to apply law in criminal cases despite facts that leave no reasonable doubt the law was violated, right? And so jury nullification is a mechanism and a defense which allows the jury members, as representatives of the community, to disregard both the law and the evidence and acquit defendants who have violated the letter but not the spirit of the law. And we can talk about what some of those cases would be, right? One we've used quite a bit in this class is speeding because you're drag racing versus speeding because you're trying to get someone to the hospital who's dying, right? Technically, both could be punished, right? But maybe the jury is going to acquit a defendant who sped to get a loved one to the hospital because they violated the letter but not the spirit of the law. They weren't driving recklessly just because. I'll give you another example. Two brothers were out in the woods on four-wheelers, driving around, doing whatever you do on four-wheelers. One of the brothers fell off his four-wheeler, flipped it, broke his neck, and he was paralyzed from the waist down. His other brother visited him in the hospital every day, and after a couple months of living like that, he said to his other brother, I don't want to live like this. This is not living. I was very active before, very athletic. I cannot be a burden to our family the rest of their lives because I'm paralyzed from the neck down. I want you to kill me. His brother said no. They went back and forth for a while, and eventually the healthy brother walked into the hospital with a shot-off shotgun and shot his brother in the face. He was teary-eyed while he did it. He was very upset. He got arrested. He confessed to doing it. There's no question about whether he did it. Hospital security cameras showed him doing it. And his basic defense was, imagine if your brother was in that situation. What would you do? He said, I had no choice. I had to do that for him because he asked me to. And the jury actually ended up finding him not guilty for the murder. It was capital murder. It was first degree. It was premeditated. It was planned out. It was very clear that he intended to commit murder that day. But he did it because his brother asked him to do. And so he did violate the letter of the law, but is that really the spirit of the law? Now, granted, you could contrast that with like Dr. Kevorkian, who did a lot of physician-assisted suicide, and you could argue that he wasn't violating the letter of the law either, or the spirit of the law either, but he was convicted. So really, it just kind of depends on the case. If you look at the history of jury nullification, 1735, the Zinger case, there was a quote saying, jurors have the right beyond all dispute to determine both the law and the facts, and where they do not doubt of the law, they ought to do so. And so it really, you see that even in the Navigational Acts also, jury nullification is referenced. Jury nullification became an integral part of the system of justice because if the jury didn't have the right to nullify, then really it wouldn't matter. The jury wouldn't really be elevated to this level of judges. They wouldn't really be elevated to have all this power if they were just, if the jury's finding was inevitable, there was no point in having a jury then, right? So why do we give jurors this right? Well, we've already kind of talked about that, right? It's an exercise of discretion in the administration of law and justice, right? And it's also a check on prosecutorial indiscretion. It's kind of viewed as this great corrective in the administration of law, because if we have an overzealous prosecutor who's decided that they're just going to start charging people willy-nilly on very flimsy evidence, the jury has the right to say, no, that's not okay. The prosecutor can't do that. The judge can't do that. We need there to be, the people have more rights than this. And it gives the judicial system a legitimacy it would not otherwise possess. Again, if juror decisions were inevitable, then there would be no point to have them, and the people really wouldn't have any power. So really, even though a lot of people whine and complain quite a bit about being called up for jury service, other than voting, serving on a jury is the best way and the most power that an ordinary citizen will have in our society, because we can say to the government, no, we're not going to accept what you guys are saying is true unless you prove it. Man or woman in the jury box, formation of public policy, right? This actually, jury nullification actually kind of makes law in an extent, right? And it's one of the most significant principles of a democracy. Jury nullification is truly the embodiment of the conscience of the community. And again, because it informs us about the values of the society in what people find guilty and not guilty, right? I don't think that the society in George Zimmerman or Casey Anthony's case said we're okay with minors getting murdered. I don't think that's what it was. It was more saying we don't like the government or the media telling us what to do. We need to be proven beyond a reasonable doubt that the person is guilty. Now, granted, do I think Casey Anthony was guilty? Yeah. Do I think George Zimmerman was guilty? Yeah. Right? But it had to be proven. You can't just call it in. You can't just let the media decide, right? We need it proven to the community. And the societies, at least Central Florida in Casey Anthony and George Zimmerman's case, said, no, you can't just phone this in as an easy case. You need to prove it to us. It's also control over policymakers, right? Policymakers are going to stop passing bad laws if juries keep overruling them, right? And it also gives the people the involvement in the government. Not only does it legitimize the government, but the execution of the law is more important than making the law. That's a quote from Thomas Jefferson there. The execution of the law, how the law is carried out, is more important than the making of them, right? It doesn't matter what laws we pass. If we don't carry them out well, it's an issue. Now, one of the biggest controversies of jury nullification is that jurors are not told about their power to nullify. In some states, jurors are specifically told that they must follow the law, whether they agree with it or not. So they're actually told the opposite of their right to nullify. Why do you think that is? Why are they not told about this right? It's such a fundamental right. And I've just spent this whole lecture making this strong argument about why it's so important, and yet they're not told about it. Well, the main reason for it is because people are very, very concerned that that if we tell jurors of the right to nullify on really, really hard cases, the jurors are just going to say not guilty because they don't want to have to make a decision. And that could also be a problem, right? We don't want jurors to be lazy or phone it in or say, God, we've been here for 2 days, we're over it, let's just find him not guilty and be done with it because we have that right. And so we don't tell them about their right to do it, but when it does happen, we allow them to do it. Now, whether you agree with that or not, that's kind of the way it works. In the United States v. Daughtry, jury nullification coexists with the legal practice of telling the jury they must follow the law. There's nothing illegal about telling them they must follow the law. The way the jury operates may be radically changed by telling them the option to nullify. It has potential, jury nullification has potential to encourage anarchy, right? Which makes sense, because people just say, yeah, we're going to find everything legal. We're going to say first-degree murder is legal in any case, and then it would be a problem. Also, there is subtle and informal communication that could convey this right, according to U.S. v. Daughtry, and so there's no need to expressly be told. It also might put untoward strain on the jurors if we told them about that, because then they might feel this extra responsibility of, oh my gosh, is the decision we make today going to have these long, wide-reaching consequences? And also, it needs to be so extreme of a disagreement that they feel it's their duty to go against the law. We want jury nullification to be taken seriously, right? So we don't tell them about it, again, according to U.S. v. Daughtry, because it needs to be so extreme that it is their duty to actually violate the law. So here are some discussion questions. Obviously, we're not going to discuss these because it's a lecture. But why is there so much resistance to telling the jury about the power to nullify? We've already kind of talked about that. Should the decision about whether to tell the jury about its power be dependent on the goal of the nullification? Right? So should nullification only be allowed in those cases in which there's a noble goal? Well, some would argue that. Well, what consequences would there be? Well, who decides what's noble and not noble, right? How do we decide what the greater good is or isn't? And obviously there are some major drawbacks to jury nullification as well as benefits, and hopefully we've done a pretty good job of explaining those here today. So anyway, that's all on this lecture. This will be the last lecture before the final, and so if you have any questions, as always, please let me know.